Good morning, everybody. Thank you for having me. So again, my name's Andrew, and being a financial planner, today is Advanced Healthcare Directive Day. The Advanced Healthcare Directive specific documents are healthcare driven, healthcare focused. So what I'm wanting today to do, to hopefully accomplish, is to explain to you when these advanced healthcare directives are in place or being utilized, what other implications there are in your financial world, and what other roles and documents there may be that would complement the advanced healthcare directives as well. So I want to go over some of those different roles, and you'll see that I will oscillate between while one is living in their life, and then also estate planning measures after an individual has passed away, how his or her family may be able to help with that, and what best route to take to make that most easy for the family. So how I work with my clients, because each of my clients and each of your individual stories is unique. So it's my goal to understand your entire situation, and then from there be able to advise and coordinate with your legal professional, your tax professional, to help implement and execute an overarching plan for your finances. Through that, like I said, an advanced healthcare directive is not utilized by me or my office or, for the most part, most financial institutions. But instead, like what Dave was going over with the PowerPoint, there's other things like powers of attorney. There's other things like trading authorization that I will get, those roles that I will hopefully better explain to help you understand how those can be utilized at that simultaneously when advanced healthcare directives could be used too. So any questions up front about any of that or anything that I need to specifically address for anybody? No? Okay. So I will go over a few roles, terminology about while one is living. And so to start, I saw when I walked in, Dave had already touched on a power of attorney. In my scope of work, and when I work with my clients on their finances, this is going to be typically a general, durable power of attorney. And so when you are working with your legal professional on your estate plan, that is something that typically I can utilize and speak to an individual's power of attorney on his or her behalf and still act as if I am speaking in most cases with the account owner. A power of attorney allows for a lot of flexibility, but to be very clear, a power of attorney stops being effective once an individual has passed away. So if I am, for example, if I am the power of attorney for my own mother, I can no longer be the power of attorney for my own mother once she has passed away. So power of attorney is only effective for in life. I want to stress that a power of attorney should be utilized and executed as soon as you feel comfortable doing that. This should not be a document that you try to coordinate or implement when you are also probably starting to use those advanced healthcare directives. Power of attorneys it's a very effective document, and it can be used in many different applications. So that's my take on that. Go ahead, yeah.
Is a medical durable power of attorney different?
It is.
Okay.
It is. Yep. And so when I've seen it in the past, is if a client submits to me a medical durable power of attorney, my office cannot accept that as an actual power of attorney, and we can't act on that.
Got it.
Yeah. Yeah.
Can you talk a little bit about the restrictions that can be placed on a POA at different times that you can change from time to time?
Yeah, so that's going to be dependent on what the power of attorney document specifically states. So it is very unique. But in many cases, a general durable power of attorney in my scope of work will allow me, again, my legal department will always interpret that document and tell me what my limitations and restrictions would be. But in most cases, that does offer me and the power of attorney and the account owner quite a bit of flexibility to accomplish what we need.
Does that power of attorney,
It doesn't allow that individual to have any action over the accounts. It's really just about communication about those accounts, isn't that correct?
In a lot of cases, it would allow for action.
It doesn't.
There are controls in place where is if the power of attorney wants to be having money pulled out of the account owner's account and put into the power of attorney's name, or they want to change beneficiaries on the account owner, there's definitely limitations on that. And I think Keenen, our attorney who's going to speak, will be able to touch on that even more so I don't want to steal any of his thunder. But yes, typically a general durable power of attorney will allow for action to take place.
In coordination with the will?
No, and that's a good question, Howard, is that a will really is only going to be effective mostly after life. And so the power of attorney in life of the account owner, a power of attorney will help step in that person's life to help with the account owner's daily living and needs, and yes, still their wishes and desires. Are you okay if I move to the next role? Oh, yes.
and I have a question about the power of attorney living 12 hours away,
Uh-huh.
and things start to change here. Would a person notify you to talk to that person if it was on a financial issue?
Would the power of attorney talk to me? Is that your question? Or somebody else talk to me?
Well, I'll just be blunt, I'm a caregiver, as you know, but if my client had a need, but I'm here and trusted, but the fellow that had the power of attorney lives 12 hours or so away, could I contact you to contact him?
Yes. Yep.
If you didn't already have the permission to intercede in that way?
Yep, that's correct. So if a caregiver, for example, and how this would go when I work with my clients, if a caregiver has a concern or a change in requests, but that caregiver is not a power of attorney, the caregiver can absolutely contact me and tell me what is going on. But I cannot take that as action. I cannot act on that news. So I would then need to either speak with the account owner or the power of attorney to be able to take appropriate action once I've received that news. The next term, and this is very unique to the financial industry, is it's a role called a trusted contact. And this is actually, within the past couple of years, a very newly implemented role that we are doing our best to add to our clients' accounts. What a trusted contact is if I, as a client's financial advisor, cannot get in contact with the owner of the accounts, but I need to be in touch with them, a trusted contact allows me to call the trusted contact and just find out where the account owner is, what their whereabouts are, if everything is okay. What a trusted contact is not is if I call the trusted contact and ask, is the account owner okay? Is the account owner doing well? The trusted contact cannot say, yes, he or she is doing well. Now send the account owner $10,000. We need to take care of that. The trusted contact is not authorized to act on the account, but the financial services industry has found that sometimes a client maybe goes on a month-long river trip and does not have cell phone service, and we need to reach out to the trusted contact to even make sure that the account owner is okay and well. So I think that may have came out in 2019 or 2020, and we try to always ask our clients about adding a trusted contact. Any questions about that one? No? Okay. The next one that's also very unique to the financial services industry would be what's called trade authorization. So this is a general durable power of attorney, like we had talked about, is in place and effective for much more than just an account that my client may have with me. That same document can be utilized at different places. A trade authorization is only effective for that exact account that the account owner gives specific authorization to the person who has trade authorization. So I think for an application in some of your cases may be, I may not be comfortable granting power of attorney to somebody today, but if something does happen, I want to grant trade authorization on an account where I have money to be able to help, that trade authorization can be in place, things can happen, but it's absolutely less effective and does not transfer to other places like a power of attorney.
So if your client has multiple accounts,
Mhm.
you can specify just one account? Yes, okay.
That's correct. Yep. So it's not all encompassing with all accounts with me. We have to, each document authorizing trade authorization is for each account. Yep. Any questions on that one, on differentiating that to a power of attorney? And then there's a couple more that I think Keenen will be able to touch on as well, but I just want to talk a little bit about how that comes into play in my practice. Is a successor trustee. Sometimes when trusts are in place for a person's specific estate planning goals, I sometimes see a successor trustee step in while a person is living. A successor trustee can step in, and that may be a different person than who established the trust, to help out with day-to-day living and their wishes and goals.
But this is only if the person is living?
No, a successor trustee is going to be for, it could be in life and it could be after life. Yep. And this is another issue that I do run into, is a power of attorney cannot be effective or work on a trust. So that is something that's a little nuanced, and that's why a successor trustee can be a person who helps step in instead of a power of attorney on a trust. And I know that's getting a little complex, so I can always field questions afterwards on that. Hold on real fast. So you're pondering, so I want to give you still.
So your POA and your trust, two entirely separate entities, and one is not overlapping or having anything to do with the other. Is that my understanding?
At my office, in my practice, that's correct. Keenen may explain otherwise, but that's how.
Automatic, like would I write that into my trust? But also, because my trust may designate a different person that is, what do they call it, in charge of my estate,
Yeah.
the executor of,
Yep.
you know,
Yep.
could be a family member or somebody outside of the family. But if what's in my trust financially are part of what you're referring to as a trust?
Yes.
And I have a separate one just for the financial part.
That's correct. And Keenen is going to get into this and be able to explain it a lot more eloquently than I will be able to. But a trust and a personal representative that you're just explaining as an estate are two different things. They can coexist, but they also sometimes cannot as well.
Okay, so if I die,
Mm-hmm.
and I have those two different pieces, the trust that you're under, does that automatically move into the trust as part of the whole estate? If my executor doesn't have that authority to then designate, do I have to be specific within the writing of the trust? What happens to that now? The person of trust gets ousted and somebody else takes over, or he continues to be in charge of it?
It depends on the document, whether that's your will or a trust, but those are two different things. Yep. And those can be two different parties. Those could be the same party. But those are two different things. Yeah. So I know I went through quite a few roles of what I see and what we utilize while an account owner, a client of mine, is living. I also want to touch on what arrangements can be made to prepare for the event of when a client passes away. I'm sure that you all have heard about beneficiary designations. I just want to stress that beneficiary designations are a very useful vehicle to efficiently transfer assets to the individuals, the entities of your choosing. And so I would invite all of you to absolutely confirm and double check who your designated beneficiaries are. Where things do get a little unique is that beneficiary designations is not always a one size fits all for everybody. And so, like I had said earlier, when I do work with my clients who all have unique stories and unique desires, we have the flexibility to pick and choose when beneficiaries make sense, but we also coordinate with my clients' estate planning attorneys to make sure that beneficiary designations, a will that, like Connie had mentioned, a trust, making sure that we're thinking about the whole entire picture. Because, for example, when you list transfer on death beneficiaries on an account, upon the account owner's passing, whatever his or her will states, that does not happen on the account because you have designated those beneficiaries. So I want to stress that's going to be, that those are two different things. The beneficiaries on your will and the beneficiaries on those accounts could be the same thing, but at times they may not, and at times there's going to be instances where it makes sense for your will or your estate planning document to govern, but then there's also going to be other instances or certain types of accounts where it really makes sense to list your beneficiaries. From a tax planning perspective, most specifically.
If you have a home, can you have a pay on death for your home? Or if your child says, oh, why don't you just put my name on the house before I die? And then I heard that he would have to pay taxes.
Yeah.
And whatever the house, like say if I lived another 10 years, the house would then be greater value.
Even more valuable.
And
Yeah.
he would have to pay this huge amount of tax.
Yeah.
So it's better to do a pay on death and not put a child on your deed right now.
I don't always want to, I don't want to give a blanket statement saying that it's for sure always better. But in most cases, we do not necessarily recommend in your life deeding or adding your child onto your home. And that's, yes, you perfectly explained the tax planning aspect of that. If you put your child on if you put your child on your home before your passing, you do not get to utilize what's called a step up in cost basis. So your child or the eventual beneficiary could potentially owe additional capital gains tax if you put the child on during your life. But those instances are exactly what we talk to our clients about, because there could be some real cost savings and tax savings on one's estate. To answer your other question about listing a beneficiary on your home, though there are some vehicles that allow for that in Colorado, but Keenen will be able to talk better about that too. Yeah. And then another unique thing that I would definitely encourage everybody to really think about is if you have retirement accounts, whether that's a 401k, an IRA, a Roth IRA. The tax code as it stands today, it is a lot more tax friendly and efficient to have your beneficiaries listed on those types of accounts specifically.
As beneficiaries.
Yep.
I have a question. How does it work when it's a minor child?
So in minor children, did everybody hear her question? She had asked what happens if a minor child is a beneficiary and inherits while being a minor. Minors may be listed as beneficiaries. That's no problem. And those assets that the beneficiary inherits will be held in trust until that beneficiary is of legal age. And that is typically age 18 or 21, dependent on the state.
What is it in Colorado?
So 18 is when the individual may take possession.
Held in trust by whom?
I didn't hear you, I'm sorry.
Held in trust by whom?
Typically, at Edward Jones, the company that I am with, it would typically be held in trust. Those assets still would be held and retained at Edward Jones, and the personal representative of the estate or a designated trustee for that estate would help authorize any action on that account. Yeah. But it does not have to be held in trust by that specific financial institution. That's not a requirement. Yeah.
Okay, at what point, the durable power of attorney ceases to exist at the death of the client?
Correct.
Okay, then does that, you still retain, who do you represent then? Or who is your client?
Upon a person's passing, that account essentially becomes frozen.
Okay,
I cannot act until I am either provided a death certificate, and then once I'm provided a death certificate, my office then has authorization to transfer those assets to the designated beneficiaries, and my office would then contact those beneficiaries and complete that process. If beneficiaries are not listed upon the death of the account owner, I would then have to receive probate documents, letters of testamentary, appointing the personal representative so I can then speak to that individual about the accounts. If I do not have either of those, I cannot do anything.
then is that, at that point, does an executor come into play?
Personal representative and executor, I would say, are pretty interchangeable terms. Yep. So for the executor or personal representative, that is the person who's court-appointed, authorized to act on behalf of the estate.
Is there any advantage in tax planning to making one of your designees as a nonprofit, say like Hospice of Montezuma? Is there the ability to not only to remember them, but as far as tax advantages, is there a point in doing that?
There is. And if our clients, I'll reverse a little bit. A person may always be able to gift or have certain assets or investments, for example, transfer to a nonprofit in his or her life. And those giftings made in life allow for tax deductibility, tax savings on a contribution, plus the original account owner is not on the hook for the taxes of the profit that they have made on those investments. So that is in life. After life, if an individual lists a nonprofit as a beneficiary, those assets do get to be transferred to that nonprofit, and that amount that is transferred to the nonprofit is excluded from an individual's estate when it comes to calculating estate taxes as well. So there are definitely tax planning opportunities, and that's why when those begin to become more complex, definitely it's my job to make a call to my clients' estate planning attorneys on their behalf to make sure that we have the account set up properly to transfer those assets correctly and to the right organizations or nonprofits as well. I see I've got about 10 minutes, and I want to help. I want to help make sure everybody's on track with time. I'm just making sure I'm. Oh, there's one thing that I think is probably a little bit of a blanket statement. One thing that I have seen to be effective in when I have clients who pass away, it may not be a bad idea to have a loved one, a very trusted individual, as a joint owner on a small checking account. Because, like I said, if a client of mine who passes away has passed away and I do not have a death certificate, or I do not have the probate documents, that account stays frozen until I have that. That can take a couple days. That can take some time. You just never know. So, my general recommendation to my clients about having a small imbalance, low imbalance checking account and having a very trusted loved one listed as a joint owner allows for, upon one of those individuals, one of the account owner's passings, the other individual continues to get to transact and pay bills and take care of day-to-day expenses, when sometimes I have had experiences where I don't get to send any money to those loved ones until I have the proper documentation, and that's frustrating and even more difficult during a tough time.
So are you talking about like the account that they're paying their bills from? Monthly bills, that kind of thing?
Yeah, I think that's a very good option. The reason why I'm specifically saying a low checking account balance, nothing too sizable, is once you add a joint owner, that other owner is an owner. And whether that person has creditor issues, bankruptcy issues, other things, once you have a joint owner, that gives way to, you kind of open Pandora's box at that point in time. So having a kind of your daily living checking account balance that can that you pay groceries for and bills, listing a very trusted or loved one on that to help continue paying for those bills might not be a bad idea.
I would suggest also joint ownership of, if there's a safe deposit box,
Oh yeah.
because that also will be unattainable until the probate's taken care of.
And that reminds me, Becky, I think that's accurate. Probably a place to not keep your estate planning documents that need to be read is not a safety deposit box. Because the people that need to read your will or your trust or whatever that is to get into the safety deposit box, for them to be allowed to, that has to be read. So if those documents are locked in there and nobody else has any copies, that's going to present some issues.
On that subject, visiting my folks, they're talking about a lot of this stuff and planning and giving me information. And they made me a co-executor of their trust with an attorney.
Mm-hmm.
They had removed a sibling of mine from that role. I'm not on the safety deposit box, but a sister is, not my sister, but my mom's sister, and then the sibling that they removed from the trust executorship. And the deed to the house is in the safety deposit box. And I said, okay, so what if something happens? And apparently there's some rigmarole around, like, adding me onto that safety deposit box. And I was like, well, let's not push it. Like, they're all living, and that's all fine, and we'll work it out. But is that something that I should really say, the rigmarole may be worth that, to address that?
I think it could be. It just depends on what their intention is for the trust that you mentioned, for what is their intention for what the trust should own.
Right.
Some people may want their safety deposit box to be excluded from the trust, for example. But if their original desire is to have the trust own as much as possible, while they're all alive and well, I would invite you to probably get going on that. Yeah. Connie, you have a question. I'm sorry.
I wanted to follow up on her first question with regard to what you were talking about a bank account. I recently had a client pass away, and her bank account, as soon as the bank was notified, that account was frozen. So if, nobody can access it now. I mean, and I went to deposit her state income tax refund into that account, because the family can
Yeah.
At all. We can't change the way it is. She didn't have another signature on the account.
Yeah.
At all. So, choose wisely, first of all.
Yeah, absolutely. Yep.
And secondly, have it done.
Yeah, that's right.
Whether it's the person that is not your executor on
Yeah.
the will or whoever.
Yeah.
But
And
money's gone.
yeah. And share what you are doing, what your goals are. Share with the loved ones of what you're hoping to accomplish, and bring in the professionals to help make sure this is done correctly, and that you are thinking of all of the potential implications that those changes could make. So, yeah, go ahead.
On my checking account, I had my closest friend,
Uh-huh.
and she passed away. Now I put my brother, but I don't have the death certificate for my friend that passed away. So what would happen if my brother needed to do something if I passed away? Would it be frozen because I don't have the death certificate for the friend?
And according to the bank, your friend is still on the account?
Yeah.
Okay. So what?
But your brother's also on the account?
Yes, he's on the
Yeah.
account.
So once the financial institution is notified of a person's passing, even without having a death certificate, they will begin to start to freeze the account or have you make the changes necessary, like submitting a death certificate. Yeah.
Can you get anybody's death certificate?
Wouldn't her brother still be a signer on the account?
Yep. The brother would still be able to act.
They wouldn't freeze the account, he would still have access to it?
Typically, on a bank account, one can still act on that. Yeah. What other questions? Sounds like maybe one last question.
I wasn't asking a question. I was going to follow up to her not having a death certificate. Just same lines as mine. Her husband had died in previous years. I was asked to do a task, and I needed a copy of his death certificate. But it was 6 years ago, and I'm caregiver. I didn't have a clue. And the children asked me to do this. They're in different states. You can go down to the town clerk's office, and as long as that death certificate has been recorded at the clerk's office, you can, they'll give you a copy. And I didn't have to show anything that I had authorization to take it. I did explain why I needed it, you knew it right away. You need to do that to get it. If somebody passes away and their name's on your car, you have to show a death certificate to be able to sell that car or put it in your name. So that's a good place to know that is available to you.
Yeah.
Copies.
Yeah.
You can also put other documents like birth certificates and everything on file, which can also help with anybody that's going to be coming.
Yeah. I think I'm at time. So thank you very much. I have some business cards and brochures in the back. And if with your family members, please let your professionals know if they definitely are used to having these conversations. It's not always fun things to discuss, but that's what we're here for. So thank you for having me.
Thank you.